Welcome to the Legal Trifecta. This is Angela Morales, and with me today is Sandy McCorquodale. We'll be going over a Supreme Court case that the Texas Supreme Court decided in the 1990s, and we'll be going over damages in personal injury cases as well. Let's get started.
Not only a Texas Supreme Court case from the 1990s, but also a Texas Supreme Court case from this past week, because they are closely related. A lot of the work that we do is in what are called negligence cases, which is simply described mostly as the failure to act as a reasonable person would act under the same or similar circumstances, as we like to say in the law. In other words, the duty to act safely, the duty to act prudently, and the duty to just be reasonable in your conduct and not to create hazards or dangers for other people, or if you do, at least to tell them about it. And those cases, those negligence cases where you're suing for property damage or you're suing for personal injury, where your body has been injured, or where you're suing for wrongful death caused by the negligence of another, as each of them has three legs to the stool that you need to establish. One is duty, one is breach of that duty, and then the final leg is causation of damages.
The big one.
The big one, yeah. Although duty is sometimes and oftentimes argued over a lot. If you're in a motor vehicle accident case, then it's pretty easy to say. Everybody knows that you have a duty to other drivers to keep a proper lookout, to make timely application of your brakes, to avoid engaging in conduct that would cause a collision, to yield the right of way when it's time to yield the right of way. In other situations, it's not so clear as to where your duties begin and end, either as a landlord, possessor of land, or an occupier of premises, or as a person operating machinery or doing other things. So the courts in Texas have worked hard over the years to develop a number of factors that they look at for the recognition of a duty at common law. And this is all common law. There's some cases have what are called statutorily created duties, sometimes referred to as negligence per se, where a statute creates a duty saying that you should do this, or you should not do this other thing, to either engage or refrain from a particular act or omission. And in those cases, sometimes the civil courts will say, yeah, and that creates a duty that's enforceable by a third party, and you can be liable for breach of that duty. But those are called negligence per se cases. You mostly see those when you're looking at the transportation code and you're looking at rules governing the operation of motor vehicles, although that doctrine shows up from time to time in other areas. Separate from that, you have factors that are looked at by the courts where the court says we recognize the duty under these circumstances to act reasonably and to basically protect is the best word I can think of to describe what a duty is. And in other circumstances, you do not have that duty. So, and what you're at is to establish as a plaintiff the existence of the duty, the violation of the duty, and in determining the existence of the duty, the Texas courts say there are a number of factors that you should look at. And they're interrelated, and they have a component to them which is very much sort of social policy, for lack of a better word or phrase. You're looking at the risk that's posed if you impose a duty on somebody, should it be based on the fact that if they don't have a duty to third parties to do a particular act or to refrain from doing a particular act, what's the level of risk that's imposed to say that there is not a duty? As you can imagine, the higher the risks, then the greater the likelihood is that you have a duty. If the risk is that you're going to blow up a town or wreck a train or crash an airplane, then that risk factor will weigh pretty heavily towards finding a duty. If the risk is simply that somebody might sustain some minor injury or that some inexpensive piece of property might be damaged, then that factor doesn't weigh that heavily towards finding a duty. The next is the foreseeability that something could happen. For example, if you get drunk and drive at high speed on the wrong side of the highway, it is highly foreseeable that there is going to be an accident. If you are the person installing bolts on a door plug on an airplane that might blow out, then it's reasonably foreseeable that if you don't do your job correctly, that the door could blow out and somebody could get injured. If you are engaged in another activity where if you don't perform a particular act or if you omit doing a particular act, then something might happen, but it's not all that foreseeable as to what might happen, then that factor will weigh against finding a duty. Now, foreseeability is endlessly debated by lawyers, by academics, by law students. And one person's idea of foreseeability can be quite different from another person's idea of foreseeability. That it is. And one of the difficulties in examining foreseeability is looking at it from the way things were before the accident happened. Because
hindsight is 2020.
Yeah. And you can get sucked into this whole idea of, well, this happened, so it must have been foreseeable. And exactly. It's not that way at all. There are things which are unprecedented. There are things which have not happened. To use the example of the door plug blowing out on the airplane, you could legitimately go in and argue about foreseeability and say, well, we had done it this same way on hundreds of planes and the door didn't blow out. So doing it this same way, even if it wasn't the correct way, it wasn't foreseeable to us that this door was going to blow out and something was going to happen. But foreseeability is one of those factors that's very much in the eye of the beholder, and is argued about a lot within the law. Then you have the likelihood of injury, which is somebody actually going to get injured if I don't act as a reasonable person, if the law does not require me to engage in conduct that's designed to be safe, to be prudent, to be reasonable, and to protect my fellow citizens from injury through my conduct. And so those are the things that weigh in favor, particularly those three factors weighing in favor of there being a finding that a duty exists. What's the risk? What's the foreseeability of injury? And what's the likelihood of an injury? Now, against that, you say, well, there are other factors you have to look at, and there clearly are. And they include the social utility of the actor's conduct, the magnitude of the burden of guarding against the injury, and the consequences of placing the burden on the defendant. And this is why earlier on I said a lot of this duty analysis is very much social policy, because when you look at the magnitude of the burden of guarding against an injury, when you look at the consequences of placing the burden on the defendant, you're making social policy decisions about, is the time, money, and effort that we're requiring of people or companies when we impose a duty, is that so great that we should not impose this duty, or is it so light that we should impose this duty?
Yeah, almost asking, is it practical?
Exactly. Yeah. Is it a practical way to do it? And you can get into these discussions about spreading of risk, that if society is going to absorb the risk of these injuries, is it better from a social perspective for the consequences of the injury simply to be absorbed by the victim, or is it better to place a duty on a company or corporation or a wealthier individual to guard against the injury happening, and by doing that, spread the risk and divide it up among more than one person, basically, and distribute it through, in most cases, through the liability insurance systems. So you look at that, you look at those factors, and you try and figure out, is there a duty? Is there not a duty under the law? And from that, you derive these rules. Like, if you drive down the roadway, as I said earlier, you have certain duties that you owe to other drivers, and reciprocally, those drivers owe duties to you. And pretty much, in those cases that you've got a pretty substantial risk. Motor vehicle accidents occur every day. People are killed on Texas highways almost every day, certainly every week, at least one person dies. And the magnitude of the injury is large, or potentially large, when it happens. And it's foreseeable if you don't have drivers who are obeying the rules, yielding the right of way, keeping a proper lookout, not driving at excessive speed, then it's easily for almost anybody to say, well, if you don't do that, then we can foresee that an accident is going to happen one way or another. And as a lawyer I worked with for years said, that every risk of harm eventually finds its victim. And that's what foreseeability does. And likelihood of injury is definitely present there. And it's not, as we have developed through the 20th century, it's not too great of a burden to follow the rules when you drive on the roadway. And it's not imposing any excessive expense on people to say that we will operate our motor vehicles in this way, and we will, by doing so, reduce the risk of injury. The consequences aren't all that great when you place the burden on the drivers themselves. Now, separately, you have a very different social utility question when you ask about, what about placing burdens on manufacturers to include safety equipment within their vehicles, such as the federal standards saying, well, you have to have seat belts,
airbags,
or you have to have airbags. Yeah. And should you put in side airbags or not side airbags? All of these systems that have been mandated by the government, that's the same, in many ways, type of social policy analysis as you're looking at when you're creating duties in Texas. So now out of that context, you have these rules that relate to your duties when it comes to others, because many times in a negligence case, there's this urge to say that if actor A had not done that, had done something different, and controlled the conduct of actor B, then actor B would not have engaged in the conduct that caused me injury. And in those duty cases, it's much more attenuated. It's one thing to say, actor B owed me a duty not to do what he or she did and injure me. It's different than to step back and to say, actor A owed me a duty with regard to how actor A acted, acted with regard to actor number B as to what they did. And you may say, well, what does that mean? And it's very much a question of, where is there a duty to control somebody else's conduct? Because the general rule in Texas, as in many other states, is that there is no duty to control the conduct of third persons. So if you loan your car to somebody and they go out and they get drunk and they drive at excessive speed on the wrong side of the highway and they cause an accident, then you have, in most instances, no duty, because merely by lending them the car, you don't have a duty to control the conduct that they're engaged in. Now, if they're already intoxicated when they come to you, and you're aware they're intoxicated and they don't have a license, and you know their driving history is that they get in accidents with some frequency, then it's different, because then you engage in this enabling conduct of entrusting somebody.
Negligent entrustment.
And so the victim can come back and say, yeah, you have your own responsibility for your own conduct in negligently entrusting this vehicle to this incompetent driver. So there are instances where you have those duties. And so you look at employers and employees, where you've got a duty with regard to how you train your employees to do their jobs, and the negligent failure to train may give rise to liability. And you have parent and child relationships where periodically the parent can be held liable for the conduct of the child, where the parent has the ability to control and direct the conduct, but does not reasonably, safely, or prudently exercise that ability to control the child. And in those circumstances, you can have a duty that is owed directly to the injured third party. Now, the cases in Texas that discuss these duty factors try not to be overly case specific. And that was, and by say case specific, I mean the tort system in Texas and the role of duty is to have a reasonably uniform set of rules that an actor can look at and say, this is the rule that applies in this circumstance. As we like to say in law, even though law is wildly uncertain at times, and it seems like every time you ask a lawyer, can I or can I not do this, the answer is, well, it depends. So the goal is to have what is called predictability, that under similar circumstances, under similar factual patterns, the result of a lawsuit should come out pretty much the same. We don't want a system of ad hoc rules that says, under these particular and unique facts, we're going to create a duty that's not going to be applicable to anybody else. Or we're not going to create a duty, but come back next week with some other fact pattern. Maybe we will create a duty in something that is similar or under similar facts. The idea is that you want predictability and you want uniform basis for creating duties. But you get these unique situations at times that you really have to look at. This is a circumstance that will occur with some frequency, which we have never addressed before.
Yeah, like some sort of specific exception to
correct.
A general rule.
Exactly. And in the 1990 case, the old yellow cab case, which has sort of been the fountain of these particular factors, the issue was what duty did the cab company have to control the conduct of their driver, who was not an employee but was an independent contractor, and carried a gun, and then eventually uses the gun on a passenger. So, and the whole issue was, did Yellow Cab actually have any duty to prevent their driver, who was an independent contractor, from carrying a gun on the job? And weighing the factors that I've discussed, the court ultimately comes up to the idea that the cab company did not have any duty to prevent their independent contractor employee from carrying a gun on the job. So, and recently, the most recent decision, at least the one from about a week ago from the Texas Supreme Court, revisited a little bit of this whole idea of the threshold inquiry in a negligence case being duty, and noted that where there is a rule that's already in place, you do not take these factors out that I've described and revisit the whole issue of, should we create a duty under these facts or not? And in that case, the most recent one from the Texas Supreme Court, which was the Chan case, the whole issue was a person who gets injured in the roadway between a hospital and the parking lot across the street, and whether the hospital had created a sufficient situation to hold it liable for negligence in either signage or design or some other way with regard to people crossing back and forth in the middle of the block instead of going to the end of the block to cross at the crosswalks, because we're all lazy. We all want to cross in the middle of the block. None of us want to go down to the crosswalks. And I'm guilty of that. I do it all the time in McLennan County, going to the courthouse, because there's the front door to the courthouse and here's the parking lot, and they're directly opposite each other in the middle of the block. And so you just want to walk instead of going down to the corner. But kind of take things into your own hands and take your own risks when you do that. But there's a rule. There's a rule that has of long-standing effect in Texas law, which says that just because you own land, or you're what they call a possessor of land, meaning maybe you lease it or you rent it or you occupy it, but you're in control of that land and it's by a roadway, do you have a duty to protect people on the roadway from unsafe conditions on the roadway? And the answer has pretty uniformly been over the years that you do not have a duty to protect somebody in the roadway from hazards in the roadway or from the conduct of other actors in the roadway. And what the Chan case did was to come in and say, don't take those factors out of the Yellow Cab case and apply them case by case where we already have a rule. And in the Chan case, there was already a rule. And so the court goes through and says there's not a rule. Says that, there is a no duty rule. There's not a rule imposing a duty in this instance, and refers to the fact that no one would think that a land possessor did have a duty of care to others for conditions that were not caused by that land possessor, whether you own it, lease it, or just occupied it, for conditions on the public highways and streets adjacent to that land that were not created by them. And the court thus concluded that the hospital in that particular case was under no duty to control the actions of the driver of the vehicle that struck the pedestrian crossing the street. And because it did not owe a duty under the general rule, there was no need to go back and discuss these factors out of the yellow cab case that I went through before. Court said there was simply no duty in this instance, and that was the end of it. So
did the court at all discuss the factor about how the roadway impacted their decision, like the fact that it was a public road? Did that come into discussion at all?
Yeah, it went through and did an analysis and said that the hazard, and the plaintiffs in that case said, well, you've got people that cross in the middle here. You have an exit from the hospital that people use all the time. It's in the middle of the block. You have a little concrete pad that has been built by the hospital on the hospital side that people come down the stairway and here's this concrete pad, and effectively it sure looks like a crossing there. And there had been in the past a crossing on this county road where there had been a crosswalk put in, and then eventually all of the markings of the crosswalk had washed away or worn away, and the county had never come back and reinstalled the crosswalk. It wasn't at the exact place where the plaintiff was crossing. It was a little bit further down the block, but there was no established crosswalk there. And then they had some complaints about the signage, because where vehicles would exit the parking lot was offset slightly from the crosswalk, but they were in proximity. So there was this whole idea that the signage could direct somebody to exit the parking lot in a way that would pose an immediate hazard to a person attempting to cross the street in the middle of the block. And the court found that the conditions that were attributable to the hospital, the signage, the exit from the hospital in the middle of the block, the concrete pad, were not the things that actually contributed to cause the accident itself. So one question is there a duty once you've got a driver in the street and you've got a pedestrian? Is there a duty in that circumstance to somehow control or direct what either one is doing? And the court says no. And then the court in another part of the opinion goes through and says, for the things that we know the hospital did, is there anything that we can do to say, yes, that was a causative factor in this accident? And the court said, no, we're looking at the facts of the case. We don't see anything there that was a causative factor. So there was no recovery. The hospital was found to have no duty and to walk away. So it's, in any tort case, one of the things that you look at from the very beginning is there a duty? And from the perspective of motor vehicle cases, there's times where you can look at it and go, wow, there's clearly a duty, and you're off to the races. And then at times you can get to like the training and negligent entrustment cases where you're like, depending on the facts surrounding the actual training or the actual entrustment of the vehicle, there may or may not be a duty.
It'll be less clear. And then you get all the way out to things like this, like the hazard in the roadway.
which also extends this whole idea of slip and fall cases, which is, for example, if you drive over to an office building and you are going to visit a business in the office building, and you get out and you're walking across the parking lot, and can be sprinklers that have made it slick. It can be ice on the ground, it can be a hidden pothole. There can be all sorts of things that can create a slip and fall or a trip and fall. Is that the responsibility of the business you're going to see inside? If it's simply a tenant in a multi-tenant building, the answer in all likelihood is simply no. They are not the possessor or occupier of the parking lot or the sidewalk outside. That may be the owner of the building, but it's not the business that you're going to visit inside, even though that business was what brought you to that property, even though that is where that business expects you to park, and even though that is where the business expects you to walk in order to get there.
Yeah, and a foreseeable injury.
Right, yeah. And it could be a foreseeable injury too. But if it's not property that you as a business occupy, and not property that you as a business are possessing or have a right or exercising control over, then the law does not impose, then the law does not impose a duty in those circumstances. Now, enough of duty for the moment. As I said at the very outset, in these cases, we're taking a look at duty, breach of that duty, and causation of damages. So at the outset of the case, you've got duty, and then assuming that you've got duty, assuming you can establish breach, assuming you can establish causation, in other words, that the breach of the duty really did cause these damages to you. Sometimes it's very clear, sometimes not. Then what are the types of damages, the elements of damages that you can commonly recover, say in a personal injury case?
Yeah, so there are a lot of different classes of damages, a lot that people aren't aware of. I'll start off with the monetary damages. So that's what you might typically think of when someone says damages and when they're seeking compensation. So that's money. That's compensation awarded to the injured party to cover financial losses incurred as a result of the defendant's actions. Some examples: reimbursement for medical expenses, such as hospital bills and the cost of physical therapy or the cost of surgeries. And there's also property damages. That's pretty common in motor vehicle accidents. It's compensation for damage or loss of personal property caused by the defendant's actions. So that could be compensation for the repair or replacement of that vehicle. And something to note with property damage, in the case of damage to a motor vehicle, if that motor vehicle is used in your business, then oftentimes you may qualify for loss profit damages. So for example, if you, because of the car accident, you were unable to make deliveries in your business for a month while it was getting repaired, you're going to lose out on money that you would have been able to make if that accident hadn't happened. And yes, those are called loss profit damages. Something else kind of similar is loss of earning capacity in the past. So if you have been injured in a car accident or on an on-the-job injury, and you had to get surgery as a result of those injuries, you're not going to be working for a month, a few months, maybe even a year, depending on how serious that injury was. So that is considered loss of earning capacity in the past. Now, loss of earning capacity in the future, that's compensation for the projected loss of income or earning capacity resulting from the injury extending into the future. So if you've received a permanent injury that, for example, if you perhaps lost your right leg and you're now unable to drive, and that was your main source of income prior to the injury, that can definitely lead to loss of earning capacity in the future.
So on loss of earning capacity, the jury then is looking at what's your capacity to earn money? What was it like before the accident, and what is it like after the accident? Does that mean I have to show that I can't work any job?
Well, you might be able to work a different job, but maybe not earn as much income because of the career change that you'd have to make. If someone, for example, has always worked construction all their life, and that's what they know, to do and do well, they might struggle to get a job that compensates them just as well in the future because of the injury that they sustained.
Okay. So you would have or would expect more loss of earning capacity where an injury completely takes you out of doing the type of work that you've done your whole life. If you've done outdoor labor, if it precludes you from doing outdoor labor, if you've done desk jobs and you've got, for example, a vision loss that makes it extremely difficult to work with computers or screens any further, juries can look at that in assessing loss of earning capacity.
Yeah, it can.
What other types of damages are recoverable?
So a big one is pain and suffering damages. So those are non-economic damages awarded for physical pain, mental anguish, and emotional distress caused by an injury. So it's kind of subjective. It's hard to put a hard dollar amount on pain and suffering damages, but oftentimes it's what really makes a client whole again, or closest to being whole again. Compensation for, how an injury or a certain event impacted their life and how it's going to, continue to impact their life. Another one is loss of consortium damages, and that's compensation for the negative impact on the relationship between the injured party and their spouse. So if that spouse isn't able to earn income in the same way, that might cause stress in the relationship. And that's something that you can ask a jury to award for as well. And in a similar fashion, there's loss of parental consortium damages. So when that's compensation for the harm to the parent-child relationship caused by the injury to a parent. Sandy, have you ever had a case where there was a loss of consortium or parental consortium damages?
Yes. Over the years, we've had a number of cases like that. The loss of consortium damages are interesting because there's no requirement that the spouse or the parent have, that the spouse or the child have sustained the personal injury themselves. Normally in a personal injury case, you're looking at the person who was physically injured. They were killed. They had bodily injury as a result of the event. The loss of consortium steps in and says, this person who was injured had this significant familial relationship, whether it's a marital relationship with their spouse or a relationship with the parent-child relationship. And that because the injury to the injured person was so grievous, it directly impacted the relationship with the spouse, which is a lot of what you see the spousal consortium claims. The parental consortium claims are the same idea, this time built around the parent-child relationship. So if your spouse is paralyzed in an accident, as we've had clients, And so you go from, here I am with my spouse and we're active, we go out, we do things, we go to concerts, we eat out, we do all sorts of things. And then as a result of the accident, you wake up one morning and now you have a spouse who, say, is a paraplegic, is largely confined to a wheelchair. And now a great part of your life is not only, we're not doing the things that we used to go in and do to enjoy as a couple, but now a large part of my time is filled with this caretaker role that is completely different from anything that I had before. And
yeah,
so,
it causes emotional distress.
Yeah, so it's the interaction with the spouse is different. There's often a significant injury is often accompanied by significant reduction or simply loss of conjugal relationships in marriages. And it imposes on both the injured person and the spouse a whole set of stresses that were previously entirely alien to the relationship. One of the unfortunate statistics is that often the change in the marital relationship is so great that the couple winds up breaking up or getting divorced. And often because of the emotion and time and physical effort that is required of the caretaker within that relationship. And you have this accompanying effect for the injured person who often has feelings of guilt or shame that they have, even though they've been a victim, that somehow they have brought this into the marriage unexpectedly, and
feeling like a burden.
Feeling like a burden, and you hear people say that all the time. So I don't want to be a burden. Nobody wants to be a burden to those around them. And the fact of life is that when people get grievously injured, they are in some sense a burden where they have a whole series of new needs, whether it be rebuilding the house. We've had clients that have built entirely new houses to adapt to the disabilities that they have as a result of the accident, and then adapting how they eat, how they cook, how they walk, how they use the bathroom, shower, yeah, the whole host of items, and there are physical changes to houses. It's like, okay, well, I've got a shower in the house, but now I need a roll-in shower. So you get a roll-in shower. You think I've got a bathroom with a sink, but if I'm confined to a wheelchair, I need to have a sink that I can actually roll the chair under. I can roll the chair up to most current sinks, but I can't reach far enough to get to the tap. I have to be able to roll underneath. So that's an easy adaptation, but it's something that just has to be done. You may have a bathroom with a commode, and you want to be able to achieve what's called side-by-side transfer, where I'm in my wheelchair. I want to be able to lift myself, transfer myself over to the commode beside me, and then when I'm done, be able to move myself back. And if you have side-by-side transfer, then a number of people who are confined to wheelchairs can do that. If you don't have the space in the bathroom, or if you've not adapted the bathroom to create the space for side-by-side transfer, then it's much more difficult for the injured person to make effective use of the commode. And in many instances and cases we've been involved in, involving the spouse, which is very burdensome, and there's this huge lack of privacy and sort of loss of privacy for the injured person, and it's almost this feeling of intrusion for the assisting spouse.
Mm-hmm.
So loss of consortium claims are not as frequent as general, I've been injured claims, because you're looking at injuries that are severe enough to have created an injury to the marital relationship. But where they exist, they need to be pursued, and they need to be fairly compensated for in the justice system.
Yeah. And all those things that you mentioned, those are things that can be very burdensome. And that's the reason why we have pain and suffering damages, loss of consortium damages, because that's additional pain and suffering that a client will be dealing with that won't necessarily be evident in their medical bills or other hospital bills that they'll have. But definitely still injuries that they should be compensated for.
Yeah.
Yeah.
And one of the, sort of to round out this topic of damages, is a move by the Texas Supreme Court really within the last year, which is to look at non-monetary damages and how do we evaluate the amount awarded by a jury for those non-monetary damages. There's plenty of case law that's developed over the years where the case will say the amount of pain and suffering damages is uniquely within the province of the jury, and so on review, unless it's obviously ridiculously disproportionate to something, like if you trip and fall and you twist your ankle and the jury gives you $1 billion, the Court of Appeals is going to say, yeah, no, that's excessive. If they give you $1 million for a twisted ankle, the Court of Appeals will probably say, yeah, it's excessive. They give you $100,000 for a twisted ankle, that's probably within the discretion of the jury. And which is from the perspective of the Court of Appeals, that's very much we'll know it when we see it sort of approach to reviewing the excessiveness of non-monetary, non-economic damages. So, because what you're looking at there is you want to be able to put on something that says, I've had pain and suffering, or I've had mental anguish, or I've had loss of consortium. So you put that on, but then the next question is, okay, you've established that. What's the next step? How is the jury supposed to go from there to writing in a dollar figure on the jury charge, where the question is, what amount, if paid now in cash, would fairly and reasonably compensate the plaintiff for this particular injury? So the courts are looking for a situation where they want to know that there's evidence that the amount awarded by the jury is fair and reasonable. And what evidence do you need to look at in order to determine that an award was fair and reasonable? And in some sense, the courts have recognized that, reasonable compensation is really no easier to determine than reasonable behavior. And in some ways it might be harder, but the law requires the courts to look at what evidence is there of the amount of non-economic damages, and how do you conduct a meaningful evidentiary review of those determinations unless you can define what is the necessary evidence. So, and that's really where you get to the core of things, because compensation is the chief purpose of damage awards in all of these personal injury cases. The cardinal principle of damages in American law is that of compensation for the injury caused to the plaintiff by the defendant's breach of duty. They're meant to compensate victims, the awards. They're not meant to punish or deter tortfeasors. People often come in saying, oh, I want to punish them. I want to do this or that. There's only one category of damages that is sometimes awarded: punitive damages. Punitive or exemplary damages are sometimes the equivalent statutory additional damages, such as the treble damage provisions under the Deceptive Trade Practices Act or under the Texas Insurance Code, where the purpose of those damages is to punish or deter the tortfeasors. The purpose of compensatory damages is not that at all. The purpose of compensatory damages is to simply find what is a fair and reasonable amount that this defendant should be required to pay for the injury that it has caused. And how you take that simple sounding rule and apply it to non-economic injuries in the evidence is now definitely a developing area of Texas tort law. A year ago, the Texas Supreme Court handed down the Chohan case, and ever since then, people have been working on trying to figure out where the Texas Supreme Court is headed on meaningful evidentiary review of non-economic damages, and what will constitute that evidence and what will not constitute that evidence. And part of it stems from this idea that we discuss with clients, which is you can come in angry, justifiably so. You can come in morally outraged, justifiably so, over what the defendant did, over what has happened to you. But at the end of the day, the tort system, by and large, is an imperfect system. It's money. And we can recover money for you. We can't make your pain go away. We can't make you walk again. We can't restore the wage earning capacity that you used to have. We can't piece your marriage back together. We can do work to get you fair, just, and reasonable compensation. But at the end of the day, it's a check. It's money. And it will help you to put your life back together. But it's not going to fix many of the gaps that you now have in your life and the things that you have to deal with in your life that you didn't have to deal with before. Money has a great inability to compensate people for non-economic damages. And the courts are struggling with that. And it's a whole separate conversation. We've gone for quite a while in this particular podcast. That
was all very well said. And thank you, Sandy, for all of your insight. And thank you for listening to the Legal Trifecta. Catch us next month, and don't forget to subscribe wherever podcasts are available.
Great. And thank you. It was a good discussion of damages there, and I think it was very enlightening for our listeners. Thank you.
Great.
Great.